I'm Akbar Ali, Managing Director of Ali Legal, and we handle high-value corporate transactions and deal with NDAs on a regular basis. Today we're going to talk about NDAs. What are they? Where do they come up? And the dangers of not having one. At the end of the video, I'm going to provide you with 3 pointers to use for yourself. As a practitioner of corporate commercial law, I do these things every week. This is our first time creating for YouTube, so please do subscribe. As a thank you, we've provided a free template. When combined with the pointers provided at the end of the video, you can use that in your business for any scenario. You can find that in the description. So what is an NDA? NDA stands for non-disclosure agreement. I actually like to title these contracts as confidentiality agreements because I think that's a better label and a broader description for these contracts. So you can call it an NDA, a non-disclosure agreement, or a confidentiality agreement. They serve the purpose of ensuring business owners can have conversations about new projects, matters which have to be kept confidential, ideas, inventions, in the confines of an agreement whereby they keep it in confidence, and if anyone should breach that confidence, there are consequences that follow. These contracts provide for those consequences. It therefore gives business owners the safety and protection of being able to openly discuss ideas, develop projects, pursue inventions, and that's why they're so important. So a real world example of this that appeared in my practice was an automotive client. This client had developed a specific part to use within vehicles. Now, once they had developed that part, they then had to discuss these ideas with car manufacturers. If they discuss it without a confidentiality agreement in place with the right terms, the risk they run is the thing that they had developed is then exploited by another party, and their idea is essentially open to other businesses to make use of. With the right confidentiality agreement, we were able to ensure that that inventor of that particular car part was protected from that exploitation from third parties and therefore advance their business in an appropriate manner. So where do you see an NDA in a corporate deal? Now, the example I just gave was a commercial matter. It's the day-to-day functions of a business. It's developing a product, selling, buying and selling, day-to-day stuff. In corporate transactions, NDAs are just as, if not more important. This is where somebody has decided to buy or sell a business or receive an investment, and there's a capital event taking place or a transaction taking place. So it's ever more important to have an appropriate confidentiality agreement which frames those discussions. As you will appreciate, these conversations are secret, they are subject to confidentiality. When a business is for sale, the seller of a business doesn't want to tell everybody about a business being sold, so they enter into a confidentiality agreement with vetted buyers in order to then frame that conversation, protect the conversation, keep it between them whilst they advance that deal and close that deal. So the very first document that is entered into at the start of a corporate deal is a confidentiality agreement. So why might you be nervous on disclosing that you're about to sell your business? Your customers might become aware of this. It can disrupt your employees. Essentially, your operations and almost every facet of your business can be impacted by a disclosure like this. So when you do have an appropriate party to have that discussion with quietly, that's when the NDA is put in place between you both to have those discussions in a quiet manner. What if you don't have a non-disclosure agreement in place? Now, if you don't have a non-disclosure agreement in place, whether it's a commercial matter or a corporate matter, you will have some protection from common law if the matter is significant, but the common law is old, it's outdated, and it doesn't give you any kind of certainty in framing the conversations. So when you have a contract, and in general, the benefit of a contract is you have certainty of outcome. In the absence of that contract, you don't have the certainty that you require to make your decisions. And this is also an opportunity to see how your counterparty is negotiating with you. So NDAs have this power to be a strategic tool for you to use. It allows you to discern the operation technique, possibly even the psychology of your counterparty, whether that's buyer or seller, the person on the other side. You can get to know them through the act of putting an NDA in place and negotiating that document. Now, this document is relatively short form. It's relatively inexpensive compared to all the other contracts you need to get yourself into with this person. So it lets you know early and cheaply who you're dealing with and what they're going to be like. It also brings you across as a professional operator. You have your contracts ready to go, and it lets the other person know on the flip side that they're dealing with somebody who has their house in order, who's prepared, who's professional. The template that I'm giving you is a mutual template. What this means is it protects both sides in a balanced and fair manner. If the party you're dealing with isn't prepared to enter into an NDA confidentiality agreement with you, particularly a mutual one, then don't deal with them. So here we are. These are the 3 things you need to personalize your NDA. Number 1, make sure you get the parties right. Are you dealing with a company? Search the company on Companies House. Make sure the name, the company number, and the registered address are clearly stated on the NDA. This applies for both sides. If you're not dealing with a company, you're dealing with an individual, make sure their full name and address is there. You might also want to include their date of birth. This is about identifying who the parties are to the contract. I often see businesses not including full party details, and therefore the contract simply doesn't apply to the right party and the rest of it is redundant. Number 2, defining purpose. Now if you scroll down to purpose in our free template, you will see that there is a blank area here where you have to explain what the purpose is about, whether it's a corporate transaction, whether it's a commercial matter, whether you've invented something new. Make sure you're specific and clear in this definition in describing what is the purpose of the conversation. That will then make sure the other terms in the contract apply in the manner you expect them to. Number 3, the free template that we've provided is a mutually protecting template. That means both parties are protected, and we've done this on purpose. At Ali Legal, we believe that business transactions should be done in a fair, balanced and pragmatic manner. A mutual NDA is a great way to start because both parties are on an even keel, and if they exchange confidential information between them, they're both protected, not just one side. You can change the template if you so wish to a one-sided protection. Sometimes this is appropriate, but 9 times out of 10, the right template to use and the right footing to set off from is a mutual contract. Now, you have a free template from a corporate law firm, and the point is to personalize that template. Make sure you don't broadcast your business and make sure your confidential information remains protected. Don't forget to subscribe. My name's Akbar Ali, corporate lawyer. Do not sign unless I've said it's fine. Click the link below to download the template.